Under Article 47, the NDC is obliged to consider reports NEC. As I have submitted, this consideration of reports does not involve the NEC reviewing executive decisions of the NEC. The NDC, which meets every 5 years, cannot be, even within the architecture of internal dispute resolution mechanism under the Constitution, an organ that reviews disciplinary decisions made under that architecture, which incidentally does not include the NEC. Because under the Constitution of ODM and by Article 74, sub-Article 2, once a resolution is made to remove...
Who manages your wealth, legacy, and connects you with investment opportunities in Kenya and globally?
At Standard Chartered, family businesses, business owners, and corporate executives have entrusted us with over $2.3 billion.
As the only international bank in Kenya, we bring you global expertise and a wide range of investment solutions right here at home.
Your wealth is guided by certified relationship managers who are supported by insurance and investment specialists.
And they consented to my learned friends' counsel for the first respondent appear not to have appreciated. And they consented to the granting of the application in the interim pending this hearing. Some of the orders that they consented to included this tribunal has jurisdiction. By that consent order, they are stopped from arguing otherwise. I pray that the complaint be allowed, all the prayers it seeks be granted, with costs to the complainant. That is all.
Thank you, Mr. Okel. Any member of the bench who has a question? Honorable Musau, Honorable Chepkoni, Honorable Muzna, Honorable Abdirahman, any questions for council?
No question from my side, Chair.
Question from my side either, Chair.
Yeah, I have no question as well. Okay. Very well. So allow us to consult and return with a date for judgment.
Chair, with your permission, even as you return.
Yes, Mr. Makori.
From the side of the first respondents, we would wish to plead that we be given the earliest possible judgment date. There are events and actions that are being hampered by this particular case. So I request humbly is that you consider giving us the earliest possible judgment date.
Very well. Of course, it has to be dependent on the tribunal's diary and schedule, but that's always a consideration. We try to expedite matters as much as possible.
Most obliged. Thank you.
So, Senior Council Okero, Mr. Makori, Mr. Mondi, Mr. Kajong, and Mr. Wakoko, may I have your attention? So we will deliberate on this matter and make a determination, deliver a judgment on 26th March 2026 at 2:30 p.m. 26th March 2026 at 2:30 p.m. That is the earliest available date, taking into account the workload, the tribunal's workload.
Most obliged. Thank you.
Thank you for your cooperation and for your submissions. We'll see you then.
And thank you for hearing us.
Most obliged.
When you have the perfect response in your head, but your fingers just can't keep up. We've all been there, typing, deleting, retyping. Now
the tribunal has jurisdiction. In his submissions, my learned senior made reference to and posed a question as to who is the aggrieved party in this case. And interestingly, the suggestion made by my senior was that the neck of the ODM party is the aggrieved party. I would wish to invite the tribunal to have a look at paragraph 4 and paragraph 12 of the statement of claim that is filed in this case. Paragraph 12 in particular contains the course of action, because it is common knowledge that every pleading that originates a suit must have a course of action. The course of action, as contained in paragraph 12, followed by 13, relates to the meeting held by the NEC on 11th of February 2026 and the resolution that followed. That resolution is why we are before this tribunal. If you also look at the prayers, which are, and specifically prayer 1, the complainant seeks to have a declaration that that resolution be declared to be null and void. So therefore, it beats all logic to try and suggest that the NEC is the complainant or the aggrieved party for that matter. Having settled that issue, Chair, in our appeal, we are basically stating that there was non-compliance with Section 42A of the Political Parties Act. It's a well-known section. It has been litigated all the way to the Court of Appeal. And Section 42 and subsection A, as amended in 2022, clearly provides that the tribunal shall not hear or determine a dispute unless a party to the dispute adduces evidence of an attempt to subject the dispute to internal political party dispute resolution mechanisms. The key word is an attempt. And from the submissions that I've had this morning, coupled with the pleadings filed, it is very clear that there was no attempt. In actual fact, paragraph 15 of the affidavit in support of the complaint all to invoke IDRM. There are a whole list of authorities that have been rendered in respect of that issue. I would wish to invite the tribunal to have a look at a case digest. Authority 2, 3, and 4 speak to the issue of an attempt. And in particular, the second authority, which was decided by this tribunal, Chebere and 15 others, versus the national chair, ODM, this tribunal held very clearly that the amendment that was made in 2022 was made to enhance party harmony and cohesion. It was therefore imperative for this complainant to demonstrate that he made an attempt. And in making an attempt, it does not mean that that attempt has to be considered. That is why that proviso was put in place. So we submit that there's no demonstration of an attempt. We go further to address the issue of whether or not NEC was the final port of call within the party. It was suggested by my learned senior that there was no follow-through once NEC made a decision. I wish to invite the tribunal to have a look at Article 88 of the ODM Constitution.
Article 88?
Yes, 88.
88. Mm-hmm.
Yes, that article, Chair and members, clearly provides for amicable dispute resolution. And even further, it goes on to say that any dispute that cannot be resolved by party organs shall be adjudicated through arbitration. So in the first instance, members of the party and members with the party organs are encouraged to do IDRM, but where that fails, there's even the process provided for arbitration. The claimants did not pursue the provisos of Article 88, and therefore it cannot be hard to say that there was no room for him to initiate or to follow through on IDRM. There is a recent decision that was delivered by this tribunal on the issue of attempt. It was delivered in November of last year. That is Harrison Abo versus Nicholas Otieno Owaka. And the tribunal was very clear that there's no room for the tribunal to exercise any discretion once it is satisfied that there's no attempt at IDRM. So, Chair, we submit on that issue that there's been no attempt at IDRM. The law is clear. The issue of jurisdiction is settled, going as far back as the case of Lillian S. And we therefore submit that the preliminary objection should stand, and this claim should be dismissed for want of jurisdiction. Chair, in the remaining minutes I have, I'll go to the second issue, which will then be amplified by my colleague, Mr. Mondi, on whether the rights of the complainant were infringed and whether Article 74 of the ODM Constitution was violated. Chair, I would wish to invite the tribunal to go to the claimant's own document at page 82. Starting from page 80, we find the resolution by the NEC. That is why the reason why we are before this tribunal. In an SMS message that was sent via WhatsApp, the agenda was set out for that meeting. And as part of the agenda, it was indicated that there would be a discussion on matters arising. When you look at page 81 of the complainant's bundle, under resolution number 6, the issue of the removal of the Secretary General came under matters arising, which was part of the agenda. It is also important to mention that the SG was given full opportunity to attend that meeting. It chose not to. And in the reply affidavit that we filed at paragraph 5, that is the affidavit of Ali Madaro, we clearly indicate that the resolution of the NEC was subject to the provisions of the party constitution. And that is what the resolution also says. So that our argument remains that under Article 74(3), the complainant had the right to be heard. That right could not be exercised because the complainant rushed to this tribunal, essentially on the same day that that resolution was passed. So we have an instance where, Chair and members, the complainant does not attempt IDRM at all and admits to it in his pleadings. We have a situation where Article 88 of the ODM Constitution provides clearly for IDRM and also an alternative process of arbitration. We have an assertion made in the reply affidavit that the complainant was to be afforded an opportunity to defend himself. He, however, rushed to this particular tribunal. So in sum, as I close on my arguments, we argue that no final decision had crystallized. If the decision was final, it would have been ratified. It has not been ratified. The internal appellate architecture of the ODM party has not been fully exercised. And for those reasons, we submit that this complaint is premature and is for dismissal. We'll invite the tribunal at its own time to look at the submissions we filed, which are fairly extensive, and the case law that we submitted on the 3 issues that we presented to court for adjudication. So I'll stop there and hand over to my colleague, Mr. Mondi.
Okay, thank you, Mr. Makol.
Thank you, Chair, and members. Chair, in respect to the question as to whether the complainant's constitutional and statutory rights have been infringed and whether Section 74 of the Constitution has been violated, I want to give brief submissions. My senior, SC Okero, started by invoking some interesting concept of ostrich equivocation tactics by the ODM party, the first respondent. Chair, by the end of my brief submissions, I would hope to have persuaded this tribunal to invoke, expound, and find that the two public policy doctrines, that is of ex tupi causa and ex dolo malo no oritur action, basically meaning that no action can arise from a dishonorable cause, and that a based on legal conduct.
Mr. Mondi, I don't know if it's only me, but I seem to be losing you.
I too am having difficulty. Sure.
Yes, Mr. Mondi, just come again from.
Yeah, I was saying that by the end of my presentation,
yes,
I would wish to have persuaded this tribunal that it does invoke two critical doctrines. The first one being the doctrine of ex tupi causa non oritur, that's a Latin legal doctrine, essentially meaning that no action can arise from a dishonorable cause. And the second doctrine of ex dolo malo no oritur, that a court cannot assist one whose claim is based on his own illegal conduct. Chair, I shall be persuading the tribunal also to be conscious of the fact that in crafting the enabling statute, that is the Political Parties Act, number 11 of 2011, that the framers, that is Parliament, had in mind the issue or the aspect of having disciplined political parties that would engage in programmatic competition. The key word is disciplined political parties. Yeah, that is a concept which I honestly believe was borrowed from one of the renowned political economists, Joseph Schumpeter, who really emphasized on the significant role that is played by disciplined political parties in the process of good policy formulation. And finally, I shall be persuading you, this tribunal, that the complainant's conduct is inimical to an ordered and disciplined ODM party, so that the first respondent's National Executive Committee, NEC, had a reasonable basis for initiating the removal proceedings. We honestly submit that the complainant's constitutional and statutory rights have not been infringed or violated, we have demonstrated that under Article 74 of the party constitution, the first respondent had the power to initiate the process of removal, and that the complainant's right under Article 47 of the Constitution, as read with Section 4 of the Fair Administrative Actions Act, of course, read together with Article 74, sub-article 3 of the party constitution, in terms of issue of a notice to show cause, all these rights are intact.
Mr. Mundi, you know that we are recording. The speed at which you are moving is making it bit. Yes, you could try just to pace a bit. So you were saying that under Article 74 of the ODM Constitution,
ODM Constitution.
Yeah, the process of removal could be initiated by ODM. Mm-hmm.
By the ODM through the NEC.
Yes. Mm.
And that in so doing, the complainant's rights under Article 47 of the Constitution under Section 4 of the Fair Administrative Actions Act, and that read together with Article 74, sub-article 3 of the first respondent's constitution, that is in turn issue of notice to show cause. Chair, we submit that all those rights are intact. The problem is, and that is our submission, that the complainant jumped the gun and halted an ongoing process anchored in Article 74 of the party constitution, as read with 88 sub-article 3, which we submit lay down a well-layered IDRM process, commencing from the NEC, the NEC, with the option of a review or a ratification by specified dispute resolution organs. Those organs are specified that can review or ratify the decision of the NEC. That is the NGC and the NDC. Chair, we also submit that there is the public interest element in disallowing the order sought by the applicant. And this can be done and demonstrated by the characterization of the conduct of the complainant placed in the context of the organizational structure of the first respondent, which is by far one of the largest political parties in the country, funded by the Exchequer.
Just a minute, Mr. Mundi. Sorry to interrupt. Registry, please help with muting those who are not talking. There's Martin who's making a lot of background noise. And mute if you're not addressing the court. Martin, mute yourself or else we'll kick you out of the platform. Proceed, Mr. Mundi.
Lord, it's funded by the public exchequer. The affidavit that we filed, and I don't need to belabor the points because it's on record, enumerates instances of infractions by the complainant. And if you look at those infractions in totality, if I could just mention a few. For example, the Central Committee holds a meeting on the 27th of October 2025, endorses the position by the NEC, resolving to appoint Dr. Oburu Oginga as a new party leader. The complainant actually reads the resolution. The same complainant subsequently, in quite an array of fora, contradicts the same position. It's just one of the instances of infractions. There are around 6, 7 that we have enumerated in our affidavits. And we are saying that in the context of public interest that is attendant in the Office of Secretary General of the first respondent, and my lord, you have to look at this in the context of the organizational culture of the party. If you refer to Article 20 of the Constitution, this is a critical office. This person is the party spokesman, responsible for the management of the National Secretariat, and is a custodian of the party documents. The office is critical for proper functioning of the party. And so we are saying that in view of the stakes, and my lord, when I talk of stakes, we also have to look at it in the context that political rights of the party membership, courtesy of the expanded scope in the Bill of Rights that is enshrined under Article 38, 1B of the Constitution of Kenya, allows participation of members or rather the citizen in activities of political parties. So that when a critical question in terms of the performance of the party secretary general comes into play, it's more than just the individual rights of the person of the secretary general. There's also the question of the millions of followers or the membership of the ODM party. They have a public interest in this issue. And so that we therefore submit that the complainant's infractions as enumerated provided a reasonable basis for the first respondent's National Executive Committee to initiate removal proceedings. I submit in finality that if perhaps this tribunal may proceed to allow the complaint, then you may inadvertently end up enforcing a policy encouraging weak party discipline, encouraging fragmentation of the party system, and that would be contrary to the object of the framers of the Political Parties Act. We pray that you disallow this complaint, and in any case, like we previously, my colleague had submitted, find that in first place, there is no jurisdiction.
Thank you, Mr. Monde. Mr. Edwin.
Thank you, Your Honor. I hope I'm visible and audible.
Yes.
I have quite a number of things to mention in the few minutes that I have. And learned friends with what they have submitted, but I want to recap in a way to emphasize some of the issues that they brought out. The first point I make is that this issue of jurisdiction is not novel. The jurisprudence in PPDT is developed and it's so clear. Just in November last year, in a matter in which you were in the panel, Mr. Chairman, you said the following words with some expiration. Additionally, the tribunal has in a long line of authorities considered the various situations on what amounts to an attempt of IDRM. It is imperative that parties and counsel appearing before the tribunal familiarize themselves with the jurisprudence emanating from the tribunal and superior courts of IDRM. You were exasperated because time and again parties have, canvassed this issue before you, and the SG himself, as a practitioner, because in nearly all these cases he has been the one instructing counsels, so he ought to have known and should have known that this issue is key to be able to discuss this issue. Now, in the Madari, this decision is, I would call it, our constituency decision. It is dated. Yeah, you have it on the list, and it is Harrison and others versus Otieno, Nicholas, and Soron. And I want to call it their decision, their constituency. Then the next, just the other day, 2 months ago, you had pronounced yourself on this matter, again in the Madari constituency decision, just 2 months ago in January, in paragraph 51 to 55 in the Madari decision. And then even in 2025, in EO 05 of 2025, again springing from Madari, you pronounce yourself. Interestingly, Your Honor, the chairperson has been in all these decisions, and so we are confident on our side that, and satisfied that the tribunal will find that there is no jurisdiction if the complainant has not shown an attempt. But allow me to look at section 40 subsection 2. It is couched in negative but mandatory terms. Have anybody thought about it, that what is the import on how the legislature intended it? For example, it begins with a preposition of notwithstanding. So, because why would he begin with notwithstanding? Shouldn't it could have begun from the tribunal shall not hear and determine the dispute. Now, this notwithstanding itself qualifies, it modifies the whole of subsection 1. And ask yourself why this was. And I submit that it is a very deliberate attempt by the legislature. It is so deliberate, it is intentional. Other lawyers call it for avoidance of doubt. And so you have to show evidence of attempt for the jurisdiction to apply. And then it goes and says, unless, that's subordinate conjunction, right? In other words, there is a dependent clause which is qualified by an independent clause. That is, it must be something. It creates a conditional relationship so that you cannot have jurisdiction at all. In fact, in the change in the amended, during the amendment, I think the legislator made it more conservative that without adducing evidence of an attempt, there would be no jurisdiction. Before, there would be doctrine of exhaustion. but that amendment took away the doctrine of exhaustion and substituted it with the evidence on attempt, so that it is a single absolute imperative. That is my submission. It is absolute imperative. Absolute imperative. And then it talks about adduce evidence. That adduce evidence must be equivalent to the Evidence Act. It must be evidence that must be proportional to the Evidence Act. And so when one looks at it, it is clear that where there is admission as it is right now in paragraph 15 of the complainant's affidavit, that there is no scintilla of evidence, one would find that there is no jurisdiction. So that the test in the Chebere case in paragraph 45 will not apply if there is no evidence. Now, I listened to my senior counsel on the question of the finality of this thing. That is very misconceived, with a lot of respect, in two ways. Number one, if you consider the constitution of this party, Article 47, I think, Article 47 sets out National Delegates Convention, and in particular 4E and F. It says that the National Convention shall have the following specific powers. E and F says to receive and discuss reports of National Governing Council and NEC, and F to elect among the eligible party members national officials, blah, 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 blah. It means that when an action is taken out of 74, this process is continuous until there is NDC. It is a process. It is not an event. Until there is an NDC that has the power to elect. And that is why even the Secretary, the Deputy Secretary General is on an acting capacity. And so that therefore allows, it would have allowed the complainant to have the party for IDM, because there is space, there is time. And that is why there is Suomoto. Suomoto cannot exist on its own. If it were to exist, it would be unconstitutional. In other words, Suomoto exists because of interlocutory approach. Just the way the tribunal gave an interlocutory order, that does not culminate into the final order. You may decide at the end of the day to reverse your decision, right? So when you see this word Suomoto in 74, it means it is interlocutory. And so, with a lot of respect, my senior, as well as the former SG, has grossly misconceived the process. I don't have some minutes, but I think I just want to say, the last thing I want to say is that in function in a political party, the office of the chair and the office of the Secretary General and the Treasurer. These three offices are the, I would call it, alter ego of the party. Today we are talking about an individual. But is anybody thinking about the millions and thousands of members of this party who cannot exercise their political rights under Article 37? Is it 37? 37, yes. 38. They cannot exercise their political rights under Article 38 just because three people are fighting. So it is, and that goes to the question of public interest that my learned friend discussed. As soon as that is detected, a responsive political party must look at the thousands of its membership and put an end to infractions which would deny them to enjoy their political parties. Now, quickly, the issue of dispute brought by my learned friend is interesting, very interesting. The ostrich equivocation, and I am very delighted that was brought. But the issue is this: what is a dispute? And when does a dispute arise? A dispute is only mentioned in section 41. In fact, the legislature assumed that a dispute is an English word, which would naturally it's not a special word. In its natural existence, a dispute arises when somebody is aggrieved or somebody controverts issues that are against him. Until that, there is no dispute. There couldn't be a dispute by NEC. NEC cannot have a dispute by itself. It's not logical. But when the subjects of NEC decision are aggrieved or complaints on a certain set of facts, then that is a dispute. That is when and only when a dispute is determined. And then it says that then it gives the jurisdiction under 41 determination of disputes and how disputes are done. So the manner in which my senior went, I think it will be the first time I've had that submission. But that being the case, a dispute cannot be by the persons who are making the administrative action of the party or the organ that is making it. It cannot be. And so I want to stop there, but I urge you that this is not an academic case. It is never an academic case. This is about people, about political rights, about people who are in the countryside who do not understand the meaning of scintillant evidence. These are people who just want to enjoy their political rights. So when a person puts himself beyond the reach of others, and he occupies a position that therefore disentitles others, this tribunal has jurisdiction, and I think that is why the legislature created this tribunal, to be able to balance the rights between an individual and the thousands of Kenyans who would wish to exercise their rights. I thank you.
Okay, thank you, Mr. Pajong. Senior Counsel Okero on agenda.
Yes.
Sorry, Mr. Okero. Mr. Wakoko. Sorry. I almost forgot Mr. Wakoko.
Thank you, Mr. Chairperson and members. Thank you so much.
Yes.
Honorable members of the tribunal, we responded to the application and the appeal by filing our response in the style of a replying affidavit. It is sworn on 18 February 2026. Chairperson, it is our position that we have been invited to court prematurely in the sense that under Section 40 of the Political Parties Act, the Register of Political Parties has not made any decision that could make a party member or a political party for that matter drag the registrar to court. So, Honorable Chairperson, as the tribunal retires, I invite the tribunal to look at Section 40, and further, I invite the tribunal to look at Section 20 of the Political Parties Act in terms of the change of party particulars, which it is our contention that we are not in receipt of that particular change, and as such, no decision has been made. I rest at that, Honorable Chairperson.
Okay, thank you, Mr. Akoko. Apologies, I almost forgot you because you said you have no dog in this fight. That's why I was almost forgetting you. We now can go to the rejoinder by Senior Counsel.
Thank you. Thank you very much. Sorry, I'm just organizing my notes here. Yes. Honorable Chair and members, Mr. Makori began, first of all, by unfortunately completely misconstruing the submissions I made in relation to who the aggrieved party was. My submissions are not questioning who the aggrieved party is in this case. My submissions were questioning who the aggrieved party was in relation to the allegations of misconduct raised against complainant, Secretary General of ODM. In fact, this actually ties in with the closing remarks made by my learned friend, Honorable Kajwang. Because as he very helpfully pointed out, that it would be a fallacy, that it would be incorrect to claim that the organ conducting administrative proceedings is the complainant. And yet, looking at the affidavit of Halima Daro, which disclosed the particulars of the allegations raised, that is the only source of allegations that the complainant has. And it is being raised by an official of the party on behalf of the party. It doesn't name whom the allegations have been made by. And so therefore, the irresistible conclusion is that it could only have been members of the NEC who were aggrieved and made allegations of misconduct against the complainant, not disclose them until 10 days after the resolution to remove him had been passed. My elder friend, Mr. Makuri's reference to Article 88 of the Constitution does not assist the first respondent in any respect, Your Honor, for the simple reason that the provisions of Article 88 and its reference to internal dispute resolution mechanism cannot operate to cure ultra-virus actions, any party official or any party organ. Article 88 of the Constitution of the ODM is only useful and invocable where it relates to proceedings under the Constitution of ODM that are lawful. Mr. Makori has submitted that the resolution of the 11th of February 2020, which purported to remove the complainant, came up in the agenda as a matter arising. Honorable Chair and members, that is a statement made from the bar. There is no evidence that they have produced to confirm that this was the case. On the face of the resolution itself, nothing suggests that it was a matter arising. The evidence before the court, including the text messages from the executive officer notifying the NEC members of the meeting, speak for itself. There was absolutely no notification, even to the members of the NEC, that there would be any deliberation under Article 74 on the conduct of the complainant. Mr. McCurry has stated that Article 74, Subarticle 3 of the ODM Constitution provides the complainant with a right to be heard. That is true, but what he is avoiding, that Article 74(3) places an obligation upon the NEC to notify the complainant prior to the making of any resolution. This is the NEC's reach of this sub-article by failing to notify the complainant prior to the resolution resulted in the NEC's proceedings being rendered an illegality. Council has also referred to the internal appellate architecture, which he claims has not been invoked. And here again, I must repeat that the only foundation of this submission, the doctrine of ostrich equivocation. No reference whatsoever has been made to any provisions of the ODM Constitution relating to this internal appellate architecture. Because, with respectfully submit, there are none. Once the NEC makes an executive decision under Article 74, Subarticle 2, it results in the removal of office of the person who is the subject of resolution. The National Governing Council has a function of receiving, considering, adopting reports from the NEC, not its executive decision. The National Delegates Conference, meeting every 5 years, has a function of electing into office bearers. 5 years, not reviewing executive decisions of the NEC. Mr. Amondi has invoked Latin phrases suggesting there should be consideration of dishonorable actions and illegalities on the part of the complainant, not specifying what would have been the infraction specific to ODM's constitutional provisions. And more importantly, when would he, the complainant, have been notified of these infractions and of an intention to deliberate on them under Article 74? The learned friend's submissions are devoid in that respect because it is clear that the provisions of Article 74(3) were breached by the NEC. And to state that it is in the public interest that political parties are disciplined to engage in the programmatic policy formulation. Council has not shown how this public interest of discipline entitles the first respondent to act in breach of its own constitution. The infractions that he has mentioned have not been tied to any breaches of ODM constitution.
Mr. Okero, I think you're muted. I think you're muted or we've lost you. You're muted or we have lost you.
Are you able to hear me now?
Yes, we can hear you now. We lost you at, you've not shown how the infractions are tied to the breach of the ODM constitution. We have lost you again. We have lost you again. Mr. Okero?
I can see that the microphone I'm using is failing. I'm trying to recharge it. If you would just give me a minute, I will log in on a different gadget. I beg your pardon.
Okay, very well.
Thank you.